Morning, ma'am, who just signed on, who's identified as iPhone. Can you hear me?
Yes,
Hi, what is your name, please?
Olivia Lloyd.
Thank you. The person who just signed on is Nokia X100. Can you hear me? Good morning, ma'am, who just popped in with the dark hair and glasses. Can you hear me? You're identified as Nokia X100. Ma'am, can you hear me now?
Yes, I can hear you.
Hi, what is your name, please?
Miranda Treeweiler.
Amanda is your first name?
Miranda.
Miranda, okay. M-I-R?
Meranda.
Thank you.
Mhm.
Mr. Slovic, can you hear me?
Yes, good morning.
Hi, good morning.
Morning.
What case are you here for this morning?
230001 LT.
Oh, got it. Okay, who are, Miranda is here. Is there any reason you need to go into a breakout room?
I guess it couldn't hurt just to double check, but
Okay, Miranda, did you hear that? I'm gonna put you in a breakout room. Just click, you'll see the invitation come up in a second. Mr. Robinson?
Hi,
Hey,
Marianne.
Hi, good morning. How are you?
Good. How are you?
I'm well, thank you. Good morning, Mr. Cox.
Morning, Marianne. How are you?
I'm really good. It's nice to see you. It's
Likewise.
nice to see you too, Steve. Sorry.
Oh, thanks, Marianne.
Do you need a breakout room?
Yeah.
Okay, hold on one second.
Okay. I'm going to meet you by click. Okay.
Good morning, Mr. Graham Mason. How are you?
I'm well, thank you.
I just made you co-host and there are some defendants that are here. If you need to take them into a breakout room, you have the capability.
Okay, thank you.
You're welcome. Good morning, Mr. Morton.
Morning, I'm just looking through everybody to see if anybody's checked in for me.
I don't believe so, not yet.
Yeah, that's probably why it's taking me longer than expected, because I'm not running across many names. But I'll continue to look, so,
Okay,
thank you.
Thank you.
Good morning. Today is Wednesday, February 22nd, 2023. This is courtroom number 1. I am Judge Martin. My docket today is landlord tenant only. If you are here for something other than a landlord tenant case, you are likely in the wrong courtroom. You may send a chat to court staff, that would be Mary Ann, and she will help you get where you are supposed to be. Our docket today looks a little different than it usually does for those of you who have been here before. We are scheduled in 15-minute blocks. There are about 8 cases scheduled every 15 minutes. We will try to keep as close to the time as possible. That being said, Mary Ann, is there anything ready to go?
No, ma'am. Mr. Robinson and Mr. Cox are in a breakout room.
Thank you.
I did make Mr. Grand Mason co-host, and there are some defendants here for him.
I'm going to join into room 3 and then start inviting some people from there if that works for you.
Absolutely. If you see a request, an invitation to go into a breakout room, please go there. That invitation will be coming from either my secretary, Mary Ann, or one of the attorneys for your apartment complex. Thank you. Mr. Slavik, your hand is up, sir. How may I help you?
I was going to dismiss the case.
You want to dismiss the case against Schreier, Weiler, and Tucker?
Yes, ma'am.
Have you advised them of that, sir?
Yes.
Would you turn your video on for me, please? This is 230001 LT. This is Andrew Slavic versus Timothy Tucker and Amanda Trier Wheeler, Trierweiler. Could you state your name for me, please, sir?
Andrew Slovic.
Mr. Slovic, today is the day and time set for the second hearing in this matter. The first hearing was on February 8th, at which time the defendants failed to appear. Based on their failure to appear, court staff sent notice to them to appear in person this morning for the second hearing. Prior to the court calling the case, you indicated that you would be dismissing this matter.
Yes, Your Honor.
Have the defendants come current in the past due rent or vacated the property?
They are within a couple $100.
Have you sent the dismissal over to the court?
Not yet.
Sir, I will make a notation in the file that you appeared this morning and that you're dismissing this action and that you will submit a dismissal to that effect. Anything else this morning?
That's all.
Thank you, sir. You have a wonderful day. Good luck to you.
Thank you. You too.
Your Honor, this is Attorney Ian Morton. I have a very brief question.
Yes, sir.
Is the court doing any adjustments to its schedule this afternoon based off of the concerns of the weather?
No, sir.
Wonderful. I just
Are you
wanted,
looking for an adjustment?
no, I am not. I just wanted to make sure.
I have not. If the attorneys call and they want adjustments, we will respond to each request accordingly.
Understood. I just was it figured out since I'm on here right now. I wanted to confirm that nothing had changed without, I hadn't quite noticed yet. So thank you.
Thank you, Mr. Morton. Good morning, Ms. McLemore.
Good morning, Your Honor. Good morning, Your Honor.
How are you?
I am great. Sorry, I'm running a little late this morning. I was over in the Romulus mediation in the wrong place.
What are you running late for?
I am here for Olivia Lloyd, and if I could speak to Mr. Morton when he gets an opportunity.
Mr. Morton is going
Absolutely.
to send you an
Absolutely.
invitation, take you into a breakout room.
Thank you.
Thank you.
Hi, good morning.
Ma'am, you're going to stop smoking before your case is called, please, and thank you. And your name for your
Yes,
name
ma'am.
so we can get you.
My name is Danielle Cedar.
What time is your case scheduled? Do you know?
I believe they said 9 a.m.
There is not a Danielle scheduled at 9 a.m. Who's your apartment Oh, Mary Ann, thank you.
9:45, Judge.
Thank you, ma'am. Ms. Cedar, we're going to mute you again. When your apartment is here, ready to speak to you, we'll get you moved into a breakout room to discuss your case.
Thank you.
Thank you. See, Marianne, the staggered time works best when people actually get here a little early to talk to the other side, not show up at 9 o'clock for a 9 o'clock hearing.
Yeah, I agree.
Silly me.
Judge, I'm gonna bop back and forth if that's okay. Try to get names on some of these people.
That's fine. I appreciate it.
Okay.
Mr. Morton and Ms. McLemore, are you ready on something?
Actually, Your Honor, she was looking for Mr. Graham Mason, I believe.
Yes, I got the wrong attorney. I'm sorry, Your Honor. I'm sorry.
Don't apologize. You just had my hopes up that we were actually going to get started.
Is Mr. Graham Mason here or?
He's here. He's in a breakout room.
Okay.
Ms. Lloyd? Good morning, Mr. George.
Hello, my name's Attorney Ian Morton. Mr. Jeremiah Webster, will you please accept the invitation that I sent you to go into breakout room number 7? If you need me to resend it, I can do so. Okay.
Your Honor.
Yes, sir.
Good morning. I was hoping to make contact with Courtney Garcia. Do you know if she's checked in?
She's here.
Could I be placed in a breakout room with her, please?
I'm going, oh, the rooms aren't labeled. I'm going to put you in number 1 with Miss Garcia, okay?
Thank you.
You're welcome.
Judge, I don't know where I am.
Ma'am, what is your name?
Tequila Standifer.
Thank you.
I have not seen Mr. Hitchcock, but there's someone else here from Romulus Housing Commission.
Don Hairston, can you hear me?
Yes, I can hear you.
What case are you here for this morning?
Did you hear me?
No,
Yes,
ma'am.
ma'am.
What case are you here for?
This is a landlord tenant matter with Victory Coin Laundry.
What's your relationship to the case, ma'am?
The property manager for the commercial space.
The attorneys are here, so keep yourself muted until we call the case, okay?
Will do.
Thank you. Mr. Morton, are you ready with something?
Yes, I am, Your Honor. It's Green Meadows versus Ashley Reed, which is 23-0160 LT.
This is 230160 LT. This is Green Meadows versus Ashley Reed. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Green Meadows.
Ashley Reed.
Ms. Reed, turn your video on for me, please.
Okay.
Mr. Morton, today's the day and time for the second hearing in this matter. How are we proceeding?
Your Honor, the parties have spoken. They've agreed to enter into a proposed consent judgment with the following terms. Was it rents retained are $4,965, court costs of $164, for a total of $5,129. Was it with a payment date of March 15th, 2023? The additional term is that March rent shall also be paid on or before March 15th, 2023. I did advise Ms. Reed of her rights under MCR 4.201. As I explained to her, it's the fact that this agreement is not final for 3 business days. Additionally, the right that she does have the right to appeal. And further, she did give me permission to sign her name to the proposed consent judgment and submit it to the court.
Thank you. Ms. Reed, were you able to hear Mr. Morton just now?
Yes.
And it's your agreement that a total of $5,129 will be paid on or before March 15, 2023?
Yes.
And that rent due for March will also be due by that date?
Yes.
And Mr. Morton explained to you that because he represents Green Meadows and you're unrepresented, that your judgment will not be final and enforceable for 3 days.
Yes.
And finally, because you appear virtually, there's not a signed consent judgment. You've authorized Mr. Morton to sign your name to the consent judgment?
Yes.
Do you have any questions, Ms. Reed?
No.
Mr. Moore's office will prepare that consent judgment submitted to the court. They'll send it upstairs to me. I'll sign it and a copy will be mailed to you at the same address that is listed in the court file currently, okay?
Okay.
Ms. Reed, you have a wonderful day. You're
You
free
too.
to
Thank
go.
you. Thank you.
Thank you.
Okay.
Thank you, Your Honor. I'll speak to the next person. And Mr. Webster, you can log off.
Good morning, Mr. Asphalt. Ms. Curry? Ms. Curry? Mr. C, did you finish your conversation with Mr. Graham Mason?
Yes, Your Honor. I believe Mr. Graham
No,
Mason.
Ms.
had-
McLemore? I called Mr. C.
Yes, we did. We talked.
Was there a resolution, sir?
Yes.
I'm sorry, Ms. McLemore, you were saying?
I'm sorry, Your Honor. I thought you said my name. I'm sorry.
It's
I have a
okay.
new computer and I cannot hear.
Were you ready with something, Ms. McLemore?
When Mr. Graham Mason returns to the courtroom.
person who just signed on identified as 1+. Can you hear me?
Yes,
What is your name, please?
Lakeisha Murphy.
Thank you. Did you say Murray or Murphy?
Murphy, they keep spelling it wrong.
Oh, okay.
Good morning, Mr. Hitchcock.
Morning.
There's already Miss Tequila Standifer in a breakout room waiting to speak to you. You should see an invitation to go into room 5 to meet with her.
Okay, got it. Yep. I'll do that.
Thank you. This is 230134 LT. This is Huron Estates versus Allen C. Your appearances, please.
Your Honor, Corey Graham Mason appearing on behalf of Huron Estates.
Alan, C.
Mr. C, where's Ashley C?
She is not here.
Where is she?
I'm not sure. She left
Okay.
this morning.
She's in default is why I'm asking. Mr. Graham Mason, you've had a chance to talk to Mr. C. How are we proceeding this morning?
We would be entering into a consent judgment with an extended time period for the writ to issue. Rent to retain possession in the amount of $2,384.78. Costs in this matter of $199.20 for a total of $25,83.98. with a writ to issue on or after March the 17th, 2023.
Mr. C, you were able to hear Mr. Graham Mason just now?
Yes.
And sir, is your agreement that a total of $2,384.78 in rent is due and owing?
Yep.
Yes.
Yes. Sorry.
And $199.20 in court costs
Yes.
for a total judgment of $2,583.98.
Yes.
And sir, you understand that because Huron Estates is represented by an attorney and you are not represented, your consent judgment would not be final and enforceable for 3 days.
Yes.
And because you appear by Zoom, there is not a signed consent judgment in the file. Have you authorized Mr. Graham Mason to sign your name to the consent judgment?
Yes.
Mr. Graham Mason's office will send the consent judgment to the court for signature. Ms. Ashley C. will be shown as being in default, but the terms will be the same. Once the court signs it, a copy will be mailed to you at the address we have on file. Do you have any questions, Mr. C?
No.
You're free to go, sir. Have a good day.
You too. Thank you.
Thank you. This is 230115 LT. This is Huron Estates versus Olivia Lloyd. May I have your appearances, please?
Corey Grand Mason, Your Honor, appearing on behalf of Huron Estates.
And Danette McLemore appearing on behalf of Olivia Lloyd.
Thank you. Today's the day and time set for the second hearing in this matter. Ms. McLemore, how are we proceeding?
I have had an opportunity to speak to Mr. Graham Mason, and we have agreed to an adjournment in this matter for 1 week so that we can work out some terms. I believe that we will have a consent agreement in this matter, but we would like to have at least 1 week adjournment or 1 week adjournment from today's date to be able to finalize our agreement, Your Honor.
This matter will be adjourned to March 1st, 2023 at 10 a.m. back here in number 1, back on Zoom. Anything else in this matter, Mr. Graham Mason?
No, Your Honor.
Anything else, Ms. McLemore?
No, Your Honor. Thank you.
Thank you. Have a good day. Ms. Lloyd, you're free to go. Has you spoken to Samantha Hiskey?
No, I have not. This is her motion to set aside a default judgment, so we may have something to talk about, but I'm not sure what we could discuss.
I'll call the case. This is 226116 LT. This is Park Estates versus Samantha Hiskey.
And Your Honor, Corey Grand Mason appearing on behalf of Park Estates.
This is Samantha.
Ma'am, turn your video on and state your name for the record, please.
Samantha Hiskey.
Ms. Hiskey, today is the day and time set for hearing on your motion to set aside the default that entered in this court back on February 7, 2023. Please proceed with your motion.
I am asking for it to be set aside due to the fact I was unable to make the first meeting. I was at the hospital with my 2 children that were sick, and I did provide documentation, but I want to put it aside because when they filed the eviction on me, that was wrong amount, and I do have evidence to prove that. Not only that, since the eviction was filed, I have been getting write-ups, and I feel that it's retaliation. Yeah, and my rent was paid in full when it was filed, when the eviction was first filed.
Are you alleging that back on December 1st, when this case was filed, you were current on your rent?
It was December 7th.
It was December 7th.
No. Whoever that is not helping.
December 1st, I had like $600 left. Yes.
And ma'am, do you believe there's currently rent due and owing, or are you current now?
There is $294 and $150 of that is late charges. I do agree with that.
Mr. Graham Mason, your response to the motion?
My response, Your Honor, is that it doesn't meet the necessary guidelines to set aside a motion for default. There's no question of fact as to whether or not a rent was still due and owing at the time of the entry of the default. I do not believe that the proofs have been made in this matter to set aside what has already been signed by this court and entered.
Anything else, Ms. Hiskey?
No, I mean, I have the proof and I've been trying to submit to their attorney, but nobody has gotten back to me on it. And I've also worked with the churches to try to resolve this $294.
Ms. Hiskey, the court will find that there is good cause for you failing to appear on February 7th. You did attach proof that there was a prescription issued on the date that you were supposed to be here in court, number one. Number two, your meritorious defense is that you were contesting. In your motion, you say the late fees and court costs, but now on the record today, you indicate that the balance was wrong. What we will do is have you back here next week, March the 1st, 2023 at 10:15. If you have documents that you want the court to consider, you submit them to the court, send a copy to the plaintiff's office.
Sounds
Your
good.
allegations that the judgment is incorrect. When the court calls the case next week, it will rely on the documents that you present and the ledger that Park Estates might present in adjusting and entering a judgment in this matter. Understood?
That is understood. Thank you, Judge.
Anything else, Mr. Graham Mason?
No, Your Honor.
Anything else, Ms. Hiskey?
Nope, that is it.
Ma'am, I will see you next week. You have a good afternoon.
Thank you.
I'm sorry, had you spoken to Ms. Borgowski?
I have, Your Honor, yes.
This is 230143 LT. This is Huron Estates versus Heather Borgowski. May I have your appearances, please?
Corey Grand Mason appearing on behalf of Huron Estates.
Ma'am, state your name for me, please.
Heather Borgowski.
Thank you. Today is the day and time set for the second hearing in this matter. Mr.
Yes,
Graham
Your
Mason,
Honor.
how are we proceeding?
Your Honor, we will be entering into a consent judgment with a minor change to the writ to issue date. The rent to retain possession in this matter is $2,757.04, costs of $199.20 for a total of $2956.24. With the writ to issue honor after the 8th of March as opposed to the 6th.
And Ms. Borgowski, do you know where Nicholas Quarez is?
I do not.
Defendant number 2 will be deemed in default. Ma'am, you were able to hear Mr. Graham Mason indicate on the record that there's $2,757.04 in rent due and owing $199.20 in cost for a total judgment of $2,956.24.
Yes,
And it's your agreement to enter a consent judgment with these amounts due and owing,
yes,
and that the judgment will further indicate that you will pay this amount or move by March the 8th, 2023.
correct.
And ma'am, you understand that because Huron Estates is represented by an attorney and you are not represented, that this judgment will not be final and enforceable for 3 days.
Yes,
And finally, because you appear by Zoom, there's not a signed consent judgment in the file. Have you authorized Mr. Graham Mason to sign your name to the consent judgment?
yes,
Thank you. Mr. Graham Mason's office will prepare a consent judgment with those dollar amounts the court just placed on the record, submitted to the court electronically. The court will sign it and a copy will be mailed to you at the address we have on record. Any questions, Ms. Borgowski?
no.
Thank you for your patience this morning, ma'am. You're free to go. You have a wonderful day.
You too, thank you.
Thank you. Mr. Hitchcock, are you ready with something, sir?
Yes, we need an adjournment of this. The defendant is getting some documents for us that may affect the amount of her rent. So I'm not sure when you can next schedule this, but we'd like to move it.
This is 230248 LT. This is Romulus Housing versus Tequila Standifer. May I have your appearances, please?
Steve Hitchcock on behalf of the plaintiff, Romulus Housing Commission. And I believe she left after we left the room. She's told me she was fine with the adjournment.
No, I don't understand that. The case will be adjourned to next week, March the 1st, 2023 at 10:15, back here with me. Courtroom number 1, back on Zoom. Anything
Okay.
else, Mr. Hitchcock?
Nothing else.
Thank you, sir.
Thank you, Judge.
Mr. Lavasser, good morning, sir.
Good morning.
Holy smokes. Mr. Morton, do you have something ready?
Yes, I do, Your Honor. Was it Holiday Woods versus Holler? It is 23-0176.
230176 LT. This is Holiday Woods versus Leslie Holler and Lindsay Holler. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of the plaintiff.
I'm sorry. Try that again, please.
Sorry. Lindsay Howard, 14 Magnolia.
And where's Leslie Holler?
She's currently at work right now, but I'm here for a school.
You can't be here for you both. Would you turn your
Oh.
video on for me, please?
Oh yeah, my video's on. Is it not coming in? I'm so sorry.
That's okay. Because she is not here, they are deemed in default, but you've had the opportunity to speak to Mr. Morton. Mr. Morton, how are we proceeding?
Your Honor, the parties have spoken, and I did advise her as the same when it came to Miss Leslie Holler. Rents retained are $3,142.45, court costs of $198 for the grand total of $3,340.45. We did agree to a proposed consent judgment with a applicable writ date of March 8th, 2023. Was it to allow the payment? Was it she's processing and getting assistance and maybe relying on her taxes? I did advise of her rights under MCR 4.201. As I explained it, it speaks to the fact that this agreement would not be final for 3 business days. Additionally, I advised of her rights to appeal. And then finally, she did give me permission to sign her name to the proposed consent judgment agreement that I would submit to the court as she's looking for a copy of that to be able to take to SER.
Ms. Holler, you were able to hear Mr. Morton just now?
Yep, I was.
And ma'am, you agree that there's $3,142.45 in rent, $198 in court costs for a total judgment, $3,340.45?
Yep.
Yes,
Yeah. Sorry. Yeah.
that's okay. And Mr. Morton explained to you that because you're not represented, that judgment will not be final and enforceable for 3 days?
Yes.
And finally, because you appear on Zoom, there's not a signed consent judgment in the file. You've authorized Mr. Morton to sign your name to that consent judgment?
Yes, I have.
His office will prepare it, submit it to the court for entry, ma'am. Copy will be mailed to you at the address we have on file. Anything else this morning, Ms. Holler?
Nope, that'll be it.
Thank you. Have a good day. You're free to go.
Thank you so much. I appreciate you guys.
Thank you. This is 225305 LT. This is Southrop Properties versus Victory Coin Laundry. And your appearances, please.
Good morning, Your Honor. Aaron Cox appearing on behalf of the plaintiff.
Good morning, Your Honor. Steve Robinson appearing on behalf of the defendant. My client is also here, Judge.
I see him. He's down in our Zoom room. Today is the day and time set for the adjourned hearing in this matter. Mr. Robinson, how are we proceeding?
Your Honor, Mr. Cox and I have reached a resolution on this matter.
He got it for me.
And it is, sir?
Yeah, I'll provide it,
Oh,
Judge.
go ahead, Aaron. Go ahead.
Your Honor, we've agreed that we're going to enter an order that says that there's now $1,249.60 due in owing. The defendant is going to be credited $749.60 upon providing proof of payment of that amount to the Romulus Water Department. That would leave a balance of $500 to be paid no later than March 6, 2023.
And Mr. Cox, how long will it take you to get that submitted to the court?
Judge, with an email address, I can submit it to you and to Mr. Robinson right now.
Mr. Cox, what I'll do is adjourn this hearing to March the 1st, 2023 at 10:30 a.m. So long as you get that agreement over before that date and time, you don't need to appear again. That's just more to keep you on top of getting it submitted than anything else. Mr. Robinson, that's your understanding of the agreement in this matter?
It is, Your Honor. Can I just, for dear my client, quick?
Absolutely.
Chima, can you hear me?
Yes, I can hear you.
Okay, do you understand what we just told Judge Martin?
Yes, I understand, sir.
And you agree with that?
I agree.
Okay, thank you. Thank you, Judge.
Thank you. Thank you, sir.
Thank you, Your Honor. Good to see you, Judge.
Thank
Good
you,
to see you,
Mr.
Mr.
Cox.
Robinson.
Thank you. Hey, Judge, I've got a 2 945s with you. Do I need to check with Mary Ann or?
There, you have people here. You can take them into a breakout room if you want to. Miss Cedar is here. Have we seen Miss Brown this morning?
I'm here.
Ms. Brown, you're gonna see, we'll get you relabeled, see an invitation to go into a breakout room to discuss this case with Mr. Robinson. When he comes back out, we'll get your case called so we can get you on with your day, okay?
Okay, thank you so much.
Thank you, Judge.
Thank you.
Hello,
Mr.
Judge.
Asquith, were you,
Yes, Judge.
who was that just screamed out?
I'm sorry, Judge. I was on the wrong link. This is Miss Toby, Courtney Toby, and I've been sitting on the other link, and they just connected me over to where I was supposed to be in front of you today. I'm sorry. I didn't mean to cut in. I'm so
No.
sorry.
No, I see you. You're fine. I don't
Oh,
know
okay.
if there's someone's here for Mr. Herman's office. If they are, we'll get you into a breakout room with them.
Okay. I thank you so
But
much.
sit
I
tight.
Okay.
No, sit tight. As long as you can see me, we see you. We'll get you where you're
Yeah, I
supposed to
see
be.
you. Thank you so much.
$500 payment now. Okay.
Miss-
Do I need to send you the proof of payment? Okay.
Mr. Asquith, I was starting to ask you, were you ready with one of your cases, sir?
I am, Your Honor.
Which one?
I'm ready, and the Randall is the defendant. That would be Belleville Point versus Randall.
Two 30105 LT Belleville Point versus Janice Randall.
Good morning, Judge. Christopher Asphalt, 53129 for the plaintiff.
State your name, please, ma'am.
Janice Randall.
Today is the day and time set for the second hearing in this matter. Mr. Asquith, how are we proceeding?
We have the terms of a consent judgment that I'd like to put on the record.
Yes, please.
All right, the parties agree that currently there's rent due and owing of $4,365.50. The defendant is to pay $2,182 by March 6th, and the balance of $2,183.50 plus March rent and late fee by March 17th.
So, Mr. Asquith, the $4,365.50, does that include the court costs that are due to date?
Yes, it does, Judge.
Thank you. Ms. Randall, you're able to hear Mr. Asquith just now?
Yes.
And ma'am, you've agreed to enter into a consent judgment where a total of $4,365.50 is due and owing?
Yes.
And it's your agreement that you'll pay $2,182 by March the 6th, 2023?
Yes,
And then $2,183.50 plus March rent and any late fee by March 17, 2023.
yes,
And did Mr. Asquith explain to you that because he represents Belleville Point and you are not represented, that this judgment will not be final and enforceable for 3 days?
yes,
And finally, because you appear virtually, there is not a signed consent judgment in the file. Have you authorized him to sign your name to the consent judgment?
yes, I did.
Mr. Asquith's office will get that consent judgment prepared, submitted to the court by email. Staff will send it upstairs. I'll sign it and the copy will be mailed to you at the address we have on file. Do you have any questions, Ms. Randall?
I do not know.
Thank you for your patience this morning, ma'am. You're free to go. You have a wonderful day.
Thank you.
Thank you. Mr. George,
Yes, Your Honor.
are you ready, sir?
I haven't had a chance to speak with Mr. Grand Mason yet, but I am ready if he is.
Well, if you're not ready, we'll get you, he's in with his client in number 3. Let's get you into number 3 so you can have a chat with him.
Thank you, Your Honor.
You're welcome. Thank you, Mary Ann. Mr. Nichols, are you ready with something?
Morning, Your Honor. I'm here for Kirkridge Park Cooperative versus Miss Linnell Pruitt. I do see Miss Pruitt here. I haven't had an opportunity to discuss the case with her in a breakout room. I think today is a second pretrial hearing. The first hearing was
I'm sorry. I couldn't hear you. You said you have not had the opportunity.
correct, Your Honor.
Ms. Pruitt is here. Mr. Nichols, what we'll do is get you made co-host and you can go into number 9 with her, please.
Thank you, Your Honor. I'm
Ms.
unaware
Pruitt.
if Miss Pruitt has legal counsel.
No.
Ms. Pruitt, you'll see an invitation to go into number 9, breakout room number 9 with Mr. Nichols. Please go there with him.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome. Mr. Joseph, good morning to you, sir.
Good morning, Judge. How are you?
I am wonderful, sir. We're going to make you a co-host and then we're going to get you into a breakout room with Miss Toby, who was here for Parkwood. And similarly, any other tenants of Parkwood will get into a waiting room to talk to you, okay?
Okay, sounds like a plan. Thank you.
Thank you.
Excuse me, Your Honor. My name is Kamira Cheatham, and I just wanted to check and see if I was supposed to be here. I haven't had a breakout room or spoke to anyone. I've been on since 9 o'clock.
Ms. Cheatham, your case is scheduled at 9:45. There is
Okay.
someone here.
Okay.
You'll get moved into a breakout room with them momentarily. Mr. Asphalt is here. Let me see if he has nothing else ready. We'll get you into a room with him. Mr. Asphalt, did you have something else, sir?
I do, Your Honor. I have Belleville Point versus, I'm sorry, Tuscan Manor versus Deshaun Johnson and Crystal Jackson.
This is 230103 LT. This is Tuscan Manor versus Deshaun Johnson and Crystal Jackson. Your appearance, please.
Christopher Asphalt for the plaintiff.
Would you state your name for me, please?
Crystal Jackson.
And where is Deshaun Johnson? Do you know?
He's at work. I wasn't aware that he was supposed to be here.
If he's not here, he's just deemed to be in default. But Mr. Asphalt, you've had this opportunity to speak to Ms. Jackson. How are we proceeding this morning?
We have the terms of a consent judgment. They are as follows. There's $424 due and owing at this time, inclusive of court costs. The defendant shall make that payment by March 6th. I would request entry of a default judgment as to Mr. Johnson with the same terms.
Ms. Jackson, you were able to hear Mr. Asphalt just now?
Yes.
And it's your desire to enter into a consent judgment with him where a total of $424 is due and owing?
Yes.
And that amount will be paid on or before March 6, 2023.
Yes.
Did Mr. Asphalt explain to you that because he represents Tuscan Manor and you are not represented by an attorney, that this judgment will not be final and enforceable for 3 days?
Yes.
And finally, because you appear by Zoom, there is not a signed consent judgment to be filed with the court. Have you authorized him to sign your name to that consent judgment? Ms. Jackson,
Yes. I'm sorry.
did you authorize Mr. Asphalt to sign your name to the consent judgment?
Yes.
His office will prepare a consent judgment, send it to the court. It will show as a default as to Deshaun Johnson. It will be emailed over, the court will sign it, and a copy will be mailed to you at the address we have on file. Do you have any questions, ma'am?
No.
You're free to go. Have a good day.
You too.
Thank you. Ms. Toby, did you go speak to Mr.
Hello?
Mr. Joseph?
No, I didn't know.
Okay, ma'am, on your screen, you should see an invitation to go into a breakout room. Please go there with him.
Okay, just a minute. I think phones, I don't know.
Mary Ann, your phone's ringing out here. I don't know who's trying to get a hold of you. Mr. Graham Mason, did you speak to Sarah?
There's an invitation on here for me to go.
I did. I spoke with both Sarah Nanasi and counsel for Mr. Barley, George.
Thank you. This is 230119 LT. This is Huron Estates versus Sarah Nanasi. May I have your appearances, please?
Oh, I'm sorry.
Yes, Corey Grand Mason, Your Honor, appearing on behalf of Huron Estates.
Ma'am, state your name for me.
Sarah Nanasi.
Thank you. Today is the day and time set for the adjourned hearing in this matter. Mr. Graham Mason, how are we proceeding?
We are proceeding with a consent judgment, rent to retain possession in the amount of $2840.62, costs in the amount of $164.60, for a total of $3,005.22, with the writ to issue on or after March the 6th.
Okay.
The 3-day rule was explained, and I sought consent to sign the defendant's name in this matter, so that this information can be filed quickly, so she can take it with her to agencies as well.
Ms. Nancy, you were able to hear Mr. Graham Mason just now?
Yes, ma'am.
And it's your agreement to enter into a consent judgment that shows there's past due rent of $2,840.62, court cost of $164.60 for a total of $3,005.22.
Yes, ma'am.
And Mr. Graham Mason explained to you that because he represents Huron Estates and you're not represented, that the judgment will not be final and enforceable for 3 days.
Yes, ma'am.
And finally, because you appear on Zoom, there is not a signed consent judgment. You authorized Mr. Graham Mason to sign the consent judgment on you.
Yes, I do.
Thank you. Mr. Graham Mason's office will prepare a consent judgment with the terms just placed on the record, email it to the court. I will sign it and a copy will be mailed to you at the address we have on file. Do you have any questions, ma'am?
No, ma'am.
Thank you for your patience this morning. You're free to go. You have a wonderful day.
Thanks, you too.
Your Honor, may
Thank
I
you.
ask a question, Your Honor? My name's Shante Johnson, and I believe I'm here for Belleville Point. And I know you called someone for Belleville Point. I just want to make sure I didn't get missed.
Ms. Johnson, your case is scheduled at 9:45. Mr. Asphalt is here from that complex. Have you spoken to the attorney that represents your landlord?
No, I have not, Your Honor.
Okay, sit tight. We'll get you moved into a breakout room with Mr. Asphalt when he's free again, okay?
Okay, thank you.
Thank you. Mr. Graham Mason. This is 230142 LT. This is Huron Estates versus Courtney Barley and Michael Barley. May I have your appearances, please?
Yes, Your Honor. Corey Grand Mason appearing on behalf of Huron Estates.
Good morning, George from Lakeshore Legal Aid, appearing on behalf of Courtney Garcia Barley.
I'm Michael Barley.
Thank you. Mr. George, you've had the opportunity to speak to Mr. Graham Mason. How are we proceeding this morning?
Yes, Your Honor. Mr. Grand Mason was kind enough to agree to a 1-week adjournment. Unfortunately, due to some technology issues, I was not able to communicate with Ms. Garcia between the last hearing and this one. So I'm going to take that week to get a handle on the case, and Mr. Grand Mason has also agreed to send me over a ledger.
And Mr. Barley, are you agreeing to a 1-week adjournment as well, sir?
I have an issue with this whole case. She was court ordered to take and file a new lease of last year. Through the 3rd District Court downtown. We have been divorced for a year.
Mr. Barley, this court cannot go into the order of the circuit court in this matter. Are you objecting to the adjournment, the 1-week adjournment in this case?
I shouldn't even be on this case, ma'am. That was my thing.
I hear you and I understand that, sir. The problem or the issue with this court is that as long as you are listed on the lease, when they file cases, Huron Estates will list you as a second defendant or first defendant, as the case may be.
Mm-hmm. And that was my issue is I'm not even supposed to be liable for the rent there, period.
Mr. Barley, I hear you and I understand it, and I've asked twice now. So what the court will do is adjourn this matter to next week, March the 1st, 2023 at 10:30 a.m. back on Zoom, back with me. Sir, if there's something that you want the court to review before that court date, you can submit it to the court.
I submitted the paperwork of my divorce decree to the Huron Estates, and they were supposed to put it in because they have already went through the hoops to try to get her to come and file a new lease.
Mr. Barley, I hear you, but I don't have it in the file. The attorneys are going to speak to each other between now and March the 1st. If Mr. Graham Mason's client is in possession of documents that shows that you should not be liable, that's something that they should take up with their client and Mr. George between now and the time the parties appear next Wednesday, okay?
All right, yes, ma'am.
I hear you and Mr. Barley, and I've made notes in your file.
All right, thank you.
Thank you. Anything else, Mr. George?
Your Honor, I missed the time that you set the next hearing for.
10:30.
10:30. Thank you, Your Honor. That's all.
Thank you. Have a good one.
You too.
Thank you. Mr. Graham Mason, were you ready with something?
Yes, we have one default that we would like to enter in the Ruiz Fondren matter.
Well, you actually have Huron Estates versus Sean Garneau and Stephen Felicki. This is 230131 LT.
And at this time, Your Honor, we would like to dismiss that matter. Paid in full.
I don't see it, so maybe.
We will submit it then, Your Honor.
Two 30135 LT Huron Estates versus Shauna Ruiz and Brandon Fondren. I've noted your appearance, Mr. Graham Mason. This matter was scheduled at 9:15 a.m. Is there a Shauna Ruiz, a Brandon Fondren, or anyone from 22014 Petite number 213 in the city of Romulus? This case was scheduled at 9:15, is now 10:05 by the court's clock. Defendants having failed to appear. Mr. Graham Mason, how would you like to proceed?
I'd like to proceed in default at this time for a possession only judgment. Rent to retain possession in this matter is $2,834.97. Costs of $199.20 for a total of $3,034.17 with the writ to issue on or after March the 6th of 2023.
Thank you. Submit your default judgment with a total due of $3,034.17. Rent date of March the 6th. The court will sign it. Thank you, sir.
Thank you, Your Honor.
Mr. Lavasser, 230036 LT. DPI Property versus Angela Grodi. May I have your appearances, please?
Good morning, Your Honor. Randy Lavasser, P41712, appearing on behalf of the plaintiff.
Ma'am, state your name for me, please.
Angela Grodi.
Thank you.
Your Honor,
Lavasser, how are we proceeding in this matter?
Your Honor, I met with Ms. Grodi in a breakout room. We did work out the terms of a conditional dismissal. Ms. Grodi was able to sign that digitally through Adobe Sign software. The terms are that there is due through the end of March, $3,700 plus $165 in costs for a total $3,865. Ms. Grodi is to pay $1,000 by February 27th and the balance of $2,865 by March 31st. Box 4B is checked, and she has signed that digitally, Your Honor.
Ms. Grodi, you were able to hear and understand Mr. Lavasser just now,
Yes, Your Honor.
and the parties have signed a conditional dismissal with a total due of $3,865.
Yes, Your Honor.
And you're to pay $1,000 by February 27th and then $2,865 by March 31st.
Yes, Your Honor.
And that's the agreement that you wish the court to enter.
Yes, Your Honor.
Mr. Lavasser's office will send it over to the court civil department by email. The court will sign it and a copy will be mailed to you at the address we have on file. Do you have any questions, Ms. Grodi?
Not at this time, Your Honor.
Thank you, ma'am. You're free to go. I'm sorry, Mr. Lavasser.
Thank you, Your Honor. I would ask the court to, if the court could put the email address in the chat, that would be helpful.
Anything else, Ms. Grodi?
No, no, Your Honor. Thank you.
Have a good day. Thank you.
You as well.
Ms. Randall,
Yes,
why are you still here, ma'am?
I was speaking with Mr. Christopher. I think I misunderstood the order. I think when we originally talked, I asked for a conditional dismissal.
Your Honor, I spoke with Ms. Randall. I'd like you to recall the case, and we'd like to enter into a conditional dismissal as opposed to a consent judgment with the same terms.
This is 230105 LT Belleville Point versus Randall. The court will make the indication in the file that this will be a conditional dismissal. Anything else, Ms. Randall?
No, that was it. Thank you.
Have a good day, ma'am. Mr. Asquith, did you have something else ready, sir?
I did, Your Honor. Olivia Curry, and the plaintiff on that one is Tuscan Manor.
This is 230192 LT Tuscan Manor versus Olivia Curry. May I have your appearances, please?
Christopher Asphalt on behalf of the plaintiff.
Ms. Curry? Ms. Curry? Let's try another one. Ms. Wallace?
Yes, I'm sorry.
Ashley
I'm
Wallace?
at work. it took me a while to unmute
No,
myself.
no, wait 1 second. Ms. Wallace, 230247 LT.
Yes,
Your file's been dismissed. You're free to go, ma'am.
thank you. Thank
Have
you.
a good day. Ms.
You
Curry,
too.
state your name for me, please.
Olivia Curry.
Thank you. Today is the day and time set for the second hearing. Mr. Asphalt, how are we proceeding in this matter?
We have a consent judgment to put on the record. The terms are as follows. There's currently due and owing $3,259 inclusive of court costs. The defendant is to pay $1,000 by March 3rd, and then the balance of $2,259 plus March rent and late fee by March 17.
Ms. Curry, turn your video on for me, please. Ms. Curry, you were able to hear Mr. Asphalt just now?
Yes,
And it's your understanding and agreement that a consent judgment will enter in this matter that shows $3,259 due,
yes,
and that you will pay $1,000 by March the 3rd, and then $2,259 plus March rent and any late fee by March 17th?
yes,
And because Tuscan Manor is represented by an attorney, you understand that the judgment will not be final and enforceable for 3 days.
yes,
And finally, because you appear on Zoom, there is not a signed consent judgment in the file. Have you authorized Mr. Asphalt to sign your name to that consent judgment, ma'am?
oh, yes, that's correct.
Do you have any questions?
No, I do not.
Thank you, Ms. Curry. You're free to go. You have a good day.
Thank you, you too.
Thank you. Mr. Morton, do you have something ready, sir?
Your Honor, the remaining matters I have are all defaults, which I believe started at 9:15 and then possibly 9:40. I think they're all 9:15s. And one 9:30.
9:15 is 230161 LT Holiday Woods versus Paige Bell Johnson. Paige Bell Johnson or anyone from 19 Birch in Belleville. Mr. Morton, the court notes your appearance for the record. This matter was scheduled at 9:15. It is now 10:12 by the court's clock. Defendant having failed to appear, how would you like to proceed, sir?
Here at this time, we'd ask a default judgment for possession be entered. Rents retained are $3,432.78. Court costs of $164, total $3,596.78. This is a non-payment of rent for possession only. I will advise that we've gotten differing information from this tenant. On one side, she says she's vacated. Another side says she's seeking assistance to be able to pay the past due balance. But my client has confirmed with me today that they did not receive the keys and do not have possession of the unit back.
Thank you, sir. At the end of the day, she's not here. The case was scheduled at 9:15. It's 10:12 by this court's clock. Default judgment, total judgment of $3,596.78. Plaintiff's office to submit that judgment for entry. This is 230164 LT. This is Holiday Woods versus Shania Burns. Shania Burns. Or anyone from 140 Birch Court in Belleville. Mr. Morton, the court notes your appearance for the record. This case was scheduled at 9:15. It's now 10:13 by the court's clock. Defendant has failed to appear, sir. How would you like to proceed?
Here at this time, we'd ask a default judgment for possession be entered. Rents retained are $4,410.11. Court costs of $164 for a total of $4,574.11. This is a default judgment for possession only. And then for the record, the defendant also did not appear at the mediation.
Thank you. This being defendant's second failure to appear in this matter. Matter scheduled 9:15 is 10:14 by the court's clock. Default judgment with the total judgment $4,574.11. Plaintiff's office to submit that judgment for entry. Mr. Freeman, have you talked to Ms. Mitchell?
Your
I'm
Honor,
sorry,
if
Mr. Asphalt.
But she's in his breakout room.
Thank you. Mr. Morton, you were starting to say.
I was going to say, Your Honor, I think I have one other one that it's at 9:30, so I figure it's 45 minutes past. I'm not sure if the court's open to take it off of that one. Correct.
230174 LT Holiday Woods versus Giovanna Burrows and Marquise Jordan or anyone from 91 Mulberry. Mr. Morton, the court notes your appearance for the record. This case was scheduled at 9:30. It's 10:15 by the court's clock. Defendants having failed to appear, sir, how would you like to proceed?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $3,398.94. Court costs of $198 for a total of $3,596.94. Again, this is a default judgment for possession only.
Thank you. Defendants having failed to appear, default judgment shall enter with the total judgment $3,596.94. Plaintiff's office to submit that judgment for entry. Thank you, sir.
I believe that's my last matter, Your Honor. There was one dismissal that had been submitted earlier this morning. I'm not sure if that was scheduled at 9:30. You should have received it, hopefully, though.
They might have pulled the file. Mr. Morton, if I see it, I'll make a note in the file. Have a good day.
I'll see you later this afternoon, I believe. Thank you.
Thank you. Mr. Nichols.
Your Honor. I had the opportunity to meet and speak with Ms. Pruitt. We are unable to reach an agreement to resolve this case today. This is a termination of tenancy case involving a housing cooperative, involving a.
This is 230094 LT. This is Kirkridge Park Cooperative versus Linnell Pruitt and Rosalind Gail Morgan. Your appearances, please.
Yes, good morning, Your Honor. Matthew Nichols, P78297, appearing on behalf of the plaintiff.
Thank you. Ma'am, state your name for me, please.
Linnell Pruitt.
And Ms. Pruitt, where is Rosalind Gail Morgan?
Deceased, Miss Rosalind Gail Morgan hasn't been on the lease in over 8 years.
Ms. Pruitt, you've had the opportunity to speak with Mr. Nichols,
Yes, ma'am.
and you cannot reach an agreement in this matter?
No, ma'am.
We tried, Your Honor, and Ms. Pruitt was very, cordial. We just could not find common ground.
Ms. Nichols, what is your defense to this termination case?
Sean Malata. I'm sorry, Your Honor, the defense?
I asked Ms. Pruitt, what was her defense to this termination case?
That the statements that was said are not true about me having a video being made of me being abusive and doing things that I did not true. The manager texting me at 7 in the morning, calling me ignorant and telling me that I'm going to be put out. The manager not taking my rent. The manager just really abusing me, but able to use the legal system to make it work in her behalf. I submitted evidence as I was supposed to the attorney February the 1st, and I have the evidence that I brought to the court for you. And they said that I have to wait until you say, okay. I was hoping that this could be resolved, but the statements is that they have videos of me doing things that I did not do, Your Honor.
Oh, excuse me. Mr. Nichols, do you have the documentation that Ms. Pruitt's referring to?
Believe I do, Your Honor. Our office received an envelope from Ms. Pruitt, and there was a variety of handwritten notes included. Looked like a copy of a text message. Statements that video footage exists that may be in the defendant or a relative of the defendant's possession. Your Honor, what I suggest and request here is that the court, I think some limited discovery may be necessary in this case, Judge. What this case boils down to is there was a prior termination notice that the co-op issued to Ms. Pruitt back in 2021 following some allegations of the defendant interfering with the cooperative staff and their ability to perform their job duties on the cooperative premises. That case never ended up going to trial. I think before it even got to court, the parties reached a settlement agreement whereby an addendum to the occupancy agreement was entered into. That addendum included, it incorporated the original.
Mr. Nichols?
Yes, Judge.
I'm going to cut you off because the question is, if you're not able to reach an agreement right now, you says a period of discovery, but is it discovery or an opportunity to have a full hearing in this matter where the parties can present documents and witnesses to the court?
Your Honor, I think both is necessary.
We'll do a period of 30 days of discovery. Ms. Pruitt, that's an opportunity to exchange information. And the court will set this matter on for an in-person hearing on April the 5th, 2023. At 1 p.m. That means, Ms. Pruitt, on that date, at that time, have all documents that you want the court to review and consider, have all witnesses present, and Kirkridge will also have whatever documents they wish to rely on and witnesses they wish to present. Understood, Ms. Pruitt?
Yes, Your Honor.
Thank you so very much. I will see you all back here on March the 5th at 1 p.m. in courtroom number 1.
Judge, Judge, you just said March 5th. Did you mean April?
April. Thank you, Mary Ann. April 5th. I wrote April 5th. Did I say? April 5th.
Thank you, Your Honor.
You're welcome, Ms. Pruitt. I'll see you then.
I can hang up. Thank you.
Yes, ma'am. This is 230096LT. This is Parkwood Manor versus Courtney Toby.
Yep, I got you.
Good afternoon, or I'm sorry, good morning, Your Honor. Joe Joseph for plaintiff.
Ms. Toby, state your name for me, please.
Courtney Jean Toby.
Thank you. Today is the day and time set for the adjourned hearing in this matter. Mr. Joseph, how are we proceeding?
Thank you, Judge. We've worked out a consent judgment if we may place the terms on the record.
Yes, sir. Thank you.
Thank you, Judge. We have a consent judgment for possession only. There's a total of $1,389 that's due plus the court cost of $198, bringing that judgment total to $1,587 even, with a writ to issue after the 6th if it is not paid. I've gone over Ms. Toby's rights under 4.201, specifically the 3-day rescission rule. She has acknowledged that that rule, and she's also given me her consent to sign her name to this judgment, and we're asking the court to allow this judgment to enter as proposed today.
Thank you. Ms. Toby, were you able to hear Mr. Joseph just now?
Yes, I was. Yes, I was.
And ma'am, it's your agreement that there's a total of past due rent of $1,389, $198 in court costs for a total judgment amount of $1,587?
Yes, ma'am. Yes,
Toby?
Yes. Yes.
That was your agreement?
Can you hear me? Yes.
Yes.
Can you hear me?
And Mr. Joseph explained to you that because he represents Parkwood and you are not represented, your judgment will not be final and enforceable for 3 days.
Yes.
And ma'am, because you appear on Zoom, there is not a signed consent judgment in the file. Have you authorized Mr. Joseph's office to sign your name to the consent judgment, ma'am?
Yes, I did.
Mr. Joseph's office will prepare a consent judgment that has those terms on it submitted to the court by email. I will sign it and a copy will be mailed to you at the address we have on file. Ms. Toby, do you have any questions, ma'am? Ms. Toby? Ms. Toby, she's still here, Mr. Joseph. She's just muted.
Okay.
If you get that consent judgment submitted to the court will sign it, mail out copies to the party.
Okay.
Ms.
sounds
Toby, you
good.
were able to hear me? Okay.
Yep, I heard you. My phone had just went acting stupid there for a minute, but yeah, I got you. I heard you.
You're okay,
sorry.
ma'am. You're free to go. You have a good day, okay?
You too. Thank you very much.
Thank you.
Bye-bye. Yeah, have a good day.
Bye-bye. This is 230098LT Parkwood Manor versus Lakeisha Murray.
For the record, Your Honor, Joe Joseph, may I have the plaintiff?
Is there anyone here from 8986 Parkwood Street, Belleville? Actually, Van Buren Township, but that's an aside. Today is the day and time set for the second hearing in this matter. The case was scheduled at 9:45. It is now 10:26 by this court's clock, the defendant having failed to appear, Mr. Joseph, how would you like to proceed?
So Judge, actually, Miss Murphy was here and I did have a chance to speak with her. We did agree to a consent judgment. It doesn't matter how we enter it. It would look the same as a default anyway, but we did speak.
Wait, I'm sorry. Her name was wrong, Mr. Joseph. Let's get her back.
Okay.
That's my
gotcha.
mistake. I'm looking for one name and it's actually a different name.
She's back, Judge.
Miss Murray, state your name for me, please. Murphy. Lakeisha Murphy.
Murphy.
I'm sorry, Mr. Joseph, you were starting to say.
I was indicating to Your Honor that we did work out a consent judgment on this matter as well.
Those terms.
Thank you, Judge. There's a total rent to retain of $2,554 and cost of $164 for a total amount of $2,718. With a writ to issue after the 6th if it's not paid. I've gone over Ms. Murphy's rights under 4.201, specifically the 3-day rescission rule, and she has consented to having me sign her name to this judgment.
Ms. Murphy, is your agreement that there's $2,554 in rent due and owing $164 in court costs for a total amount of $2,718?
Yes.
And ma'am, you've agreed to enter a consent judgment with those terms?
Yes.
And Mr. Joseph explaining to you that because Parkwood Manor is represented by an attorney, you're not represented, that judgment will not be final and enforceable for 3 days.
Yes.
And because you appear by Zoom, there is not a signed consent judgment. Have you authorized Mr. Joseph to sign your name to the consent judgment in this matter?
Yes.
Mr. Joseph's office will prepare that consent judgment, email it over to the court. I will sign it and a copy will be mailed to you at the address we have on file. Do you have any questions, ma'am?
No, just have a good day.
Thank you, ma'am. You too.
Thank you,
Feel
Judge.
free to go. Take care, Mr. Joseph.
You too. Thanks.
Thank you. This is 230100 LT. This is Tuscan Manor versus Donette Mitchell. May I have your appearances, please?
Hello, Donetta Mitchell here.
Thank you. Ma'am, you had the opportunity to speak to Mr. Asphalt.
No, I have not.
Have you spoken? You haven't spoken to any attorney this morning?
That's correct.
Okay. He's here, ma'am. We'll get you into a breakout room with him momentarily. This is Miss Johnson, Shantae Johnson.
Yes, Your Honor.
Ma'am, have you spoken to Mr. Asphalt?
Yes, I have.
This is 230106 LT Belleville Point versus Shantae Johnson. Mr. Asphalt, get your appearance, sir.
Yes, good morning, Judge Christopher Asphalt on behalf of the plaintiffs.
Thank you. Ms. Johnson, state your name for me.
Shantae Johnson.
Good morning,
Thank you, ma'am. Today is the day and time set for the second hearing of this matter. Mr. Asphalt, how are we proceeding?
I'm sorry, Judge, what was the defendant's name on this case? Oh, Shantae Johnson?
Shantae Johnson, yes.
Yeah, we have a consent judgment. The parties agreed there's $2,979.50 due and owing, and that she will make that payment on or before March 6th.
Ma'am, is that your agreement that $2,979.50 is due and owing in this matter?
Yes, Your Honor.
And that you will pay this amount or move by March 6, 2023?
Yes, Your Honor.
Did Mr. Asphalt explain that because Belleville Point is represented by an attorney, you're not represented, the judgment will not be final and enforceable for 3 days?
Yes, I'm sorry, Your Honor, you said by March 6th?
Yes, ma'am.
Yes, I agree.
And finally, because you appear by Zoom, there is not a signed consent judgment in the file. Have you authorized Mr. Asphalt's office to sign your name to that consent judgment?
Yes, Your Honor.
Mr. Asphalt's office will prepare it, sign it, email it to the court. Copy will be signed and mailed to you at the address we have on file. Ms. Johnson, do you have any questions?
No, Your Honor.
Ma'am, you're free to go. Thank you for your patience. You have a good afternoon.
Okay, you too. Thank you.
Thank you.
Judge, I have
This
been
is
trying for a while to get Miss Mitchell, for a long time, into a breakout room. And it looks like it's success. I didn't mean to interrupt you. I just wanted to let you know. I was
No,
trying.
I appreciate that because she's from the 9:30 and I know Mr. Asphalt has talked to the other, so he'll go in there with her as soon as we get Miss Cheatham, 230107 LT Belleville Point versus Kamira Cheatham. Your
Yes.
appearances, please.
Your Honor, I'm in bed recovering from surgery. Is it possible I could please leave my camera off?
Appearance, ma'am, I appreciate your explanation, but appearance is just putting your name on the record.
No, I know, but I know you're gonna ask to turn my camera on. I'm just indecent.
Thank you, ma'am.
Mhm.
I'm back, Judge.
I hear you, Mr. Asphalt. For Ms. Cheatham, how are we proceeding?
Ms. Cheatham, the parties have a consent judgment as follows. There's rent due and owing, including court costs, $2,160. The defendant shall make that payment on or before March 6th.
Ms. Cheatham, is it your agreement that there's a total due and owing of $2,160?
Yes.
And Mr. Asphalt explained to you that because you are not represented by an attorney and Belleville Point is, the judgment will not be final and enforceable for 3 days.
Yes.
And because you appear by Zoom, there is not a signed consent judgment. Have you authorized him to sign your name to a consent judgment?
Yes.
Mr. Asphalt's office will prepare that consent judgment, sign it, email it to the court. The court will sign it and a copy will be mailed to you at the address we have on file. Do you have any questions, ma'am?
No, ma'am.
You're free to go. I hope you feel better soon.
Thank you. I appreciate it. You have a good day.
You too. Thank you. Ms. Mitchell, please go back into the breakout room. Mr. Asphalt is coming to join you there.
We have to wait for the attorney to come back.
Mr. Robinson, are we ready on Danielle Cedar?
Is this your second hearing or your first hearing?
Judge, we're ready on Kayla Brown. I haven't seen Ms. Cedar yet.
230226 LT Evergreen Town and Country versus Kayla Brown. Your appearances, please.
Good morning, Your Honor. For the record, Steve Robinson appeared on behalf of Evergreen Town and Country.
State your name, ma'am.
Kayla Brown.
Thank you. Today is the day and time set for the adjourned hearing in this matter. Mr. Robinson, how are we proceeding?
Your Honor, we have a consent judgment as follows. Excuse me, rent in the amount of $4,758.56, court cost of $167 for a total of $49,2556, of which $4,044.79 will be paid on or before March 6, 2023.
I'm sorry. 4,000 what, sir? I'm sorry.
$4,044.79.
Okay.
And the balance of $880.78 on or before March 13th, 2023.
$4,044.79 paid by March the
6th.
and then $880.78 by March the 13th.
Correct, Your Honor.
Ms. Brown, you were able to hear Mr. Robinson just now?
Yes, ma'am.
And it's your agreement that there's $4,758.56 in rent and late fees due and owing?
Yes, ma'am.
And $167 in court costs for a total of $4,925.56?
Yes, ma'am.
And that you'll pay $4,044.79 by March 6, 2023?
Yes.
Is that realistic, ma'am?
Yes, ma'am.
And then the balance of 880.78 by March the 13th.
Yes, ma'am.
And Mr. Robinson explaining to you that because Evergreen Town and Country is represented by an attorney and you are not represented, the judgment will not be final and enforceable for 3 days.
Yes, ma'am.
Because you appear on Zoom, there is not a signed consent judgment. Have you authorized Mr. Robinson to sign your name to this consent judgment?
Yes, I do.
Mr. Robinson's office will prepare that consent judgment, send it over to the court. I will sign it so long as the term special was just placed on the record, and a copy will be mailed to you at the address we have on file. Do you have any questions, Ms. Brown?
No, ma'am, I do not.
Thank you for your patience this morning. You're free to go. You have a wonderful afternoon.
Thank you. You as well.
Thank you, Ms. Brown.
Thank you.
Judge, I'm going to go in the breakout room on my other matter.
Thank you, sir. Ma'am, with the pink t-shirt on?
Yes, Donetta Mitchell.
Your name, please?
Okay. Donetta Mitchell. I had an issue with trying to get into that breakout room. It didn't work.
Oh, so you still haven't spoken to Mr. Asphalt?
No, I have not. I only spoke with my landlord, and we made a payment arrangement for 11/20 for February 16th.
Hold on. This is 230100 LT. This is Tuscan Manor versus Donette Mitchell.
Good morning.
I'm sorry, Ms. Mitchell, you spoke to someone from Evergreen, but not to the attorney?
No, I actually spoke to
I'm sorry,
someone from
Tuscan Manor.
Yes, that's correct.
And the agreement was what, ma'am?
11/20 on February 16th, which has been paid. 11/20 on March 3rd. Then 895 on March 17th, and then 845 by March 31st, and I should be current after that.
Your Honor, can we try and go in the breakout room one more time just so I can discuss it with her?
Sure.
Exactly.
I'll try.
Ms. Mitchell, you'll see the invitation. Please go in there. I'm going to step off for a moment, but I'll be back when you all come back out. So Mr. Asphalt and Ms. Mitchell, you finally connected in the breakout?
We did, Judge.
Yes.
This is a recall of 230-100 LT Tuscan Manor versus Mitchell. I already have your appearances. Mr. Asphalt, how are we proceeding?
We have the terms of consent judgment to put on the record. They are as follows. There's rent, including court costs, in the amount of $1,119.50. The defendant is to make that payment on or before March 6th.
So the rest of that, what Ms. Mitchell indicated previously, is not included in any way in the consent judgment.
Yes, that is accurate.
Okay. Ms. Mitchell, after having a chance to speak to Mr. Asphalt, is your understanding there's a total due of $1,117.50?
Yes, that's correct.
And that you'll pay this amount by March 6th?
Yes, that's correct.
And because Tuscan Manor is represented by an attorney, you're not represented, you understand that consent judgment will not be final and enforceable for 3 days?
Correct.
And finally, because you appear by Zoom, there is not a signed consent judgment in the file. Have you authorized Mr. Asphalt to sign your name to the consent judgment?
I have.
Thank you. Ma'am, Mr. Asphalt's office will prepare a consent judgment with those terms. Email it over to the court. I'll sign it and a copy will be mailed to you at the address we have on file. Do you have any questions, Ms. Mitchell?
No, not as of right now. Thank you.
Thank you so much. Thank you for being so patient and doing everything you could to get back on and get connected. You have a wonderful day, okay?
Thank you. Sorry to take you all through that. Have a great one. Be safe.
Not at all, ma'am. Thank you. Bye-bye.
Thank you. Bye-bye.
Mr. George,
Good morning again, Your Honor.
good morning. What are you back for, sir?
I'm back for the Chattel Odom motion hearing.
Oh, you're a little early. Okay. I was
Yeah,
getting
a little
nervous
bit.
for a second there. Just a skosh.
Well, the mediation docket wrapped up their 10 o'clocks a little early, so.
Oh, it must be nice. Marquise,
Yeah,
what's your last name, sir?
Jordan.
Mr. Jordan, I called your case earlier.
They told me it was at 11. I got the paper right here.
Hold on one second. 230174.
Yeah, I got the paper right here. It said 11 a.m. Zoom meeting with the Zoom code.
Mr. Jordan, when you hear me say hold on for one moment. it's
Oh,
because
okay.
I'm
My
trying to
bad.
find the
Sorry.
file. So, no. You're fine. Mr. Jordan,
Yes, ma'am.
this is 230174 LT. This is Holiday Woods versus Giovanna Burrows and Marquise Jordan. Sir, you're indicating that you have a document that says you're supposed to be here at 11 o'clock?
Yes, ma'am. It's right here.
Let's see it.
Trying to flip the camera. $11 a.m. February 22nd at
No,
Was
sir,
it-
that's February 8th at 11 a.m.
oh no, oh, this is the wrong one. This is the wrong one. Hold on. I got another one. Hold on. Wrong one. I just got it out the mail with my rent paper 2 days ago. I put it all together.
I'm looking at a copy of the notice, Mr. Jordan, and it says 9:30.
And I had wrote it down too last time when they gave me the Zoom code. I wrote the time down right here on the paper too with the Zoom meeting number. Because they gave me the Zoom meeting number, it's right here too. It's trying to find. I had a whole stack of papers with my rent bills that I paid already.
Mr. Jordan,
Yes, ma'am.
stop with you. I'm looking, I have your file here in my hand. I have an identical copy of what was mailed to you. The case was scheduled at 9:30. I called it at 10:15. The attorney is gone.
Yeah, because look, I'm gonna show you right here because I wrote it down right here when she gave me the amount I owe, and I wrote the Zoom meeting with the time that she said last court date.
I understand that, Mr. Jordan, but the issue is I have what the court mailed to you and it's scheduled at 9:30. The attorney is not here. I will
Oh,
see if
okay.
we can get a hold of him to get him
Well,
back
that's
here.
probably my fault then. I thought they said 11. That's my fault.
Mr. Jordan. I don't know if we'll be able to get him back on this morning. He is not scheduled to be back until 1 p.m.
Okay.
If you sit tight, mute yourself. If my secretary is able to get a hold of him and can get him back on, great. Otherwise, I'll have you come back next week, but do not leave until I get back to you and tell you whether or not he's coming back on, okay?
Okay, I'm about to put my phone on the charger right now.
Thank you.
Okay.
Did I see Miss Medina?
The charger. On the phone.
Mr. Robinson, are we ready with Miss Cedar?
We are, Judge.
This is 2302250 LT. This is Evergreen Town and Country versus Danielle Cedar. May I have your appearances, please?
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of the plaintiff, Evergreen.
Ma'am, state your name for me, please.
Danielle Cedar.
Thank you. Today's the day and time set for the second hearing in this matter. Mr. Robinson, how are we proceeding?
Your Honor, we have a consent judgment, rent to retain $4,187.30, court costs of $167, for a total of $4,354.30. Ms. Cedar will pay one half of that, which is $2,177.15 on or before 3/13/23. The balance of $2,177.15 by March 31st, 2023.
Ms. Cedar, you're able to hear Mr. Robinson just now?
Yes.
And ma'am, you agree there's a total rent due and owing in this matter of $4,187.30, court cost of $167, for a total of $4,354.30?
Yes, ma'am.
And ma'am, you have agreed to pay $2,177.15 by March the 13th, 2023?
Yes, ma'am.
And another $2,177.15 by March 31st, 2023.
Ma'am.
And ma'am, you understand that because Evergreen Town and Country is represented by an attorney and you are not, this judgment will not be final and enforceable for 3 days?
Yes, ma'am.
And finally, because you appear on Zoom, there is not a signed consent judgment in this file. Have you authorized Mr. Robinson to sign your name to a consent judgment with these terms?
Yes, ma'am.
Mr. Robinson's office will prepare a consent judgment with the terms just placed on the record. He will file it with the court. I will sign it and a copy will be mailed to you at the address we have on file. Do you have any questions, Ms. Cedar?
So much.
You're free to go, ma'am. You have a good day. Thank you.
Thank you, Judge.
Thank you.
Judge, I have an 11 o'clock motion with you. I'm just going to hang out.
Thank you, sir. Mary Ann, should not have files left. Let's try to figure out why these are still here. Mr. Graham Mason, do you need to speak to Mr. George?
I'll speak to Mr. George, Miss Odom, and Mr. Koss in a breakout room.
Miss Odom, you'll see an invitation to go into breakout room number 1. Please go there. Mary Ann, I am going downstairs, but I'll be right back.
Okay.
Thank you.
Oh, Corey, one other thing. You're muted. There
Yes.
you go. Did you want to draft a STIP to release the escrow funds, or would you like me to do that?
If you could do that, I don't know if it requires a stipulation if we ask for it and they grant it on the bench. But if they do require a stipulation, take a crack at it. I haven't done one in a bit, so
Okay. All right.
I'm sure
We'll see what the
you're
judge
not
says.
remaking the wheel over at at legal aid on escrow orders.
No, we're not. All
Okay,
right, we'll see
very
what the
good.
judge says then.
All right, thank you.
Thank you.
Entering the court right now. Right, John.
Hello,
Hi, what is your name, please?
Alicia Spencer.
Thank you. Mr. Robinson?
Yeah, Marianne.
Hi there. Do you need a breakout room with Miss Spencer?
Yeah, I suppose we can go in the breakout room. Can you put my client in there too?
Yes, I will.
Thanks.
Yep.
This is 224799 LT. Huron Estates versus Chatel Odom. May I have your appearances, please?
Yes, Your Honor, Corey Graham Mason appearing on behalf of Huron Estates.
Good morning again, George of Lakeshore Legal Aid, appearing on behalf of Chatel Odom, who is present in the courtroom.
Thank you. This case was originally scheduled back on February 7, 2023. We adjourned the motion to set aside to this morning. The parties have had the opportunity to speak. Mr. George, how are we proceeding?
Thank you, Your Honor. Ms. Odom was able to make a substantial payment this morning. We're making good progress, and by next week, we expect her to be current. So we are asking for a 1-week adjournment on this matter. We've also agreed to release the funds currently held by in escrow by the court to Huron Estates.
And Mr. George, why are we adjourning versus the parties entering into an order that resolves this case?
That's a good question, Your Honor. I suppose it didn't come up in conversation. I'd certainly be willing to discuss that with Mr. Graham Mason.
The main reason.
Put it over, Mr. Graham Mason.
Yeah, the main reason, Your Honor, is that the 4,000 plus payment was made just today. We just really need the time to make sure that it has been hits the ledger and it's real funds. And we would be using the final, I guess, adjournment date more as a control date, because we would anticipate not coming back if everything promised takes place.
It's fine. I received a reminder from my secretary that she is not here next Wednesday. And so I'm trying not to make March 1st any heavier than it has to be. But I will adjourn this matter over to March 1st at 10:30 a.m. back on Zoom. If you resolve it in its entirety before then, just submit the stipulated order to the Civil Department. Otherwise, I will see you here on Zoom next Wednesday, March the 1st, 2023 at 10:30 a.m.
And Your Honor, are you requiring the parties to file a stipulation to release the escrow funds, or can you do that from the bench?
I thought there's an SCAO form that released the escrow.
That's fine. We'll be happy to fill it out. I just didn't know if that was something you could note and allow to happen or not.
I already wrote it in the file, but I do need an actual order. And I think there is an order. Mr. Graham Mason, I'll take care of it on our end. I'll say that. So then you don't have to worry about that piece of paper. I will see you here next Wednesday unless you resolve it before then. Ms. Odom, good luck to you, ma'am. You have a good afternoon.
Thank you. You as well.
Thank you, Your Honor.
Thank you.
Thank you. And that's it for me today. Have a good day, Your Honor.
You too, sir. Mr. Jordan.
Yes, ma'am.
My secretary called the Mr. Morton from Palace Law Firm and left a message. Has not heard back from him. I don't want to keep you waiting here. He's not due back here until 1 p.m. on an unrelated matter. So what I will do is put your case over till next Wednesday, March the 1st.
And what time, ma'am?
Oh, March 1st. Let's say 9:30 a.m. 9:30, the same time you were supposed to be here today.
9:30 a.m.
Now, Mr. 9:30 a.m. back at the same Zoom with me next Wednesday, March 1st. Now, have you paid what's due?
I was actually about to see if I could pay it today, and she said I could. I just talked to the office.
Who said you could?
The office, the lady. I got the amount right here on my paper.
There's $3,398.94 in rent due and owing. There's $198 in court costs for a total of $3,596.94.
Yeah, that's not what she said. Okay, I'm about to change that. She said 3,000. Say it again for me.
Did you just call me baby?
No, I said that's not what she said. Can you say it again for me? I did not
I
say
know
no
what I
baby.
heard you say, Mr. Jordan,
Bro,
but you know what?
my,
I'm not gonna
my
check.
girlfriend sitting right here listening to me. I did not say no baby.
Wait, Ms. Burrows is there?
Yeah.
Neither of you came to court to protect your housing on time?
I told you what the lady told me. I never said I heard anything about 9:30. My girlfriend she also heard 11 o'clock. She was here last court date too. She said 11 a.m. I wrote everything down on paper like I am right now.
$3,398.94 in rent. There's $198 in court costs. That is a total of $3,596.94.
Okay, $3,596.94. Okay.
Anything else, Mr. Jordan?
No, ma'am, that's it.
I'll see you next Wednesday, sir. Have a good day.
And it's the same Zoom meeting, right? Same Zoom code.
Same Zoom, me.
Okay.
You'll see me
Okay.
again, 9:30 next Wednesday.
So even if I paid, I still got to come, right?
I would, because even if you pay, if the complex doesn't tell the landlord, the attorney, he'll still be here expecting the case to go forward. If you
Okay,
pay,
yeah, I'm
and
just
you
ma-
have
I'm just
a
making
paid
sure.
in full, and it just
Just
every
making
time you
sure.
interrupt me, Mr. Jordan, you miss important information. So
Oh,
you go ahead
my
and
bad.
go. I'll see you. Nope,
See,
I'll see you
it's
next
actually
Wednesday.
because
Go
I'm in
ahead.
these woods, so it's like going in and out. So it's not my fault. It just sounds like you finished.
I'll see you next Wednesday.
Okay, thank you.
Take care.
You too.
Now, Marianne, you heard him. Call me baby. Are you serious? Mr. Robinson, Miss Spencer is still in the breakout room. Had you been in there with her already?
Yeah, I did. I told her to leave the breakout room, Judge. So
It must be cozy in there. She didn't come out. I'm trying to force her out now. This is 220217 LT, Evergreen Town and Country versus Alicia Spencer. May I have your appearances, please?
good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Evergreen Town and Country.
State your name for me, please, ma'am.
Alicia Spencer.
Thank you. Today is the day and time set for hearing on the defendant's motion to stay the judgment, enforcement of the judgment in this matter. The parties have had the opportunity to speak. Mr. Robinson, how are we proceeding this morning?
Your Honor, I did have an opportunity to speak with Ms. Spencer, and the issue, Judge, is that they're claiming, and she, I guess, has provided documentation to the court of some type of SARA payment. And we haven't received a payment and essentially for a year. So although Ms. Spencer has indicated that she did make a payment in January and February, notwithstanding, we have a balance of over $10,000 showing, and we haven't received anything from Sarah. Now, there was some type of correspondence that said there may be something coming within 6 to 8 weeks, but it's well past that time frame, Judge. So that's where we're at.
Ms. Spencer?
Yes.
This is your motion to
Yes.
stay the eviction in this case. It was filed back on February 6th, and your indication to the court was that you received the confirmation of the SARA in the amount of $7,180.99. And you were
Yes,
kind
ma'am.
enough, thank you, to attach a copy of the calculation sheet and the email from Mishta. But Mr. Robinson has indicated to the court that although you've attached this information, that Evergreen has not received payment.
I made a payment in January and I also made a payment in February of $590 in January and $580 in February. I have the money order receipts right here. And when I talked to Sarah, I think it was the February 6th, that was the 8th week from, they said it takes 6 to 8 weeks. That was the 8th week. And they said that that the check has been sent out and that he should receive it that week or the following week, however fast, I guess the mail goes or something. And they asked me to ask Rick to call them so they could talk to him about the check, but he said that he didn't have enough time to call them.
Sir? Have you received the check from Sarah in this matter?
No.
Ms. Spencer, unfortunately, the court can't continue to stay proceedings on the promise to pay. When you filed your motion on February 6th, the court reviewed it and told the staff to schedule it for today, which allowed a few more weeks for payment to be received. This is a judgment that entered back in November. And then the court signed the writ on December 12th of 2022, allowing plaintiff to evict based on the balance that remained due and owing in this matter. Mr. Robinson's contention and assertions this morning is that there's still quite a significant amount of money owing in this matter. Mr. Robinson.
I will own my trailer in May, Your Honor, and I get my taxes here in a week or so, and I plan on paying all the back pay. And I've lived here for 4 years, going on 5. I'm a single mom of 2 kids, and I'm really, really trying. The pandemic really messed me up. And that's when I heard about the Sierra program and got enrolled into there. And when the eviction came November 15th, my daughters had lost my mailbox key and I wasn't able to get my mail for almost a month. And that's how I missed the court date. And so I got a hold of Sierra and they told me to send them a email of the eviction notice and that they would just take care of it. And a week later, I got the approval for the Sierra check. And they said it would take 6 to 8 weeks. And yes, it's been 2 weeks longer than that. But they said he should get it anytime. And I totally understand, but I'm really trying and I can't. I've spent so much money and this is going to be mine. And I just, excuse me.
Mr. Robinson, was it something you wanted to say, sir?
No, Judge. We just asked
Miss-
the court deny the motion.
Ms. Spencer, I hear you. I understand what you're saying. I appreciate everything that you're saying. But the court's required to look at a motion to stay the proceedings for 2 things. And there are burdens that you carry in this matter. This case has been pending since January 12th of 22. Your first court date in this matter was over a year ago on February 2nd, 2022. Your motion has to give the court a good reason to stay the proceedings. A good reason is that you've paid the amount or that you've presented the amount and the plaintiff rejected it or something else. And a promise to pay by a third party is just not sufficient basis to stay the proceedings. As indicated, the court scheduled this matter more than 2 weeks after you filed your motion in the hopes that MSHDA or the Sierra agency would get the payment to your landlord, and they have not done that. The court cannot continue to delay Evergreen Town and Country taking the premises when we are now months after the November 15, 2022 judgment, and they still haven't received payment in full. For that reason, the court will deny your motion to stay these proceedings any further.
Well, what about when he does get the money from the government? Because I was told, I was told that if I don't get to stay here no longer, then he won't get the check. But I'm trying to, you know, stay to get for him to get the check. I don't, they have confirmation that they are getting the check. And I paid, you know, I paid January, paid February. I know that goes to the back, but I mean, I'm trying. I'm really trying, and yeah, within a month, everything will be taken care of. And they will have their money. It's not that I'm not trying to pay them their money. I am.
And
I don't have.
Ms. Spencer, that's why I'm saying, I hear what you're saying. The issue for the court is that there is not a legal basis to continue to stay the proceedings.
Even if it says that
Mr.
they're good. Sorry. I apologize.
If you work out something different with Evergreen, that's between you and them. The court can only address the legal matters before it, and it's the only thing that's scheduled for hearing this morning is your request to stay the proceedings. And we are more than the time that Mr. said would be needed to get the payment to you. The email says the 6 to 8 weeks. And then you have an email. So we're beyond that. We are beyond that. So the court will deny your request to stay the proceedings. Again, if you make different arrangements with Evergreen, if they accept that you've been making payments from January and February, that's an outside matter to be addressed directly between you and your landlord. Mr. Robinson, you were saying something.
I think the only thing I said, Judge, we asked the court to deny the motion.
The motion has been denied. Anything else, Mr. Robinson?
No, Your Honor. Thank you.
Anything else, Ms. Spencer?
So, I mean, how long do I have?
Mr. Robinson?
Well, Judge, I mean, the court officer has the writ in his hands. He didn't, the court officer obviously didn't make a move on this because of the pending motion. So.
So, Ms. Spencer, the answer to the question is that there is a valid writ outstanding right now. The court officer could come out to the property and execute on that writ. Anything else, Ms. Spencer?
So today?
Ice storm.
I don't have any control over that, Judge. It's up to the court officer.
So Ms. Baker, that's the answer to, I'm sorry, Ms. Spencer, that's the answer to the question that's something that the court officer, he has the writ in his hand, and it's just a matter of coordinating with Evergreen Town and Country.
Okay.
That concludes this matter.
Thank you, Judge.
Mary Ann, we'll stand in recess until our 1 o'clock docket.